Holy jeez Louise.
Wow.
All right, some people are outside your org. It's fine.
Oh, I got that message too.
There you go. The woods, yeah. Oh, my God. No, we're not gonna go back.
Diana, can you mute, please?
That was a mistake. Somebody mentioned to me, I did not
Yes.
sing it at the board, but I should.
All right, guys, for those, I know you're all on mute, so I'll just talk real quick. We've got a couple more minutes and we have 88 people attending. We had 200 sign up, so I'm going to give them a couple minutes to trickle in if you don't mind. So please just bear with us. Thank you.
Blair, should I
Yes, ma'am.
admit?
Morella.
Yeah.
Yeah, I'll do it. I got it.
I did.
But feel free.
Okay.
Yeah.
I think she's okay, right?
Yeah, she's permissed. She's allowed in.
Good, good.
Just for you, those of you guys coming in, we are just giving it a second. We had roughly 200 people sign up, and including Anne and myself, we're at 102 right now. So someone's trying to be fashionably late, I guess. So we'll give them a couple minutes if you don't mind, and then I will start the meeting and turn it over to Anne. And as I promised, I will try to be quiet after that. So just give us a few minutes, please. All right, just as I thought, there are people that are struggling a little bit to get on. So, and I'm getting messages from managers and everyone else that they need the link again. So I have shared said link again, and we'll give them, let's just plan on starting at 10:04 with or without everybody, if you don't mind. So 3 minutes.
What's that around your neck,
Blair.
Blair? I haven't seen one of those in years.
This is just for you, buddy. I figured I needed to spruce it up a little bit. I have no pants on, so it's just from here up that I look nice.
Oh, TMI, Blair, TMI.
No, I have pants. Look, everybody, I'm fully suited up for all of you guys, for everybody. So, you know, it's rare that I get to throw on a suit, and unfortunately, I like it. So I figured I'd do it today and look the part. So enjoy it. It'll be once a year.
You look very dapper.
Thank you, sir.
Correspondingly dress up as much as you, Blair. I should have, but it's July. So.
This is a breathable suit, Anne. It's okay. It's stretchy. It's got all the the attributes.
Good.
All right, 10:03. We're getting there. Another, we're up to 131. So I guess people are figuring it out. Either way, for those of you guys that are on, if there are other board members on the board with you or friends or family or whatever that's in our industry, this is recorded and or will be recorded. And there's some sort of AI transcription. I don't know how good that's going to be, but I'll share it with the managers. And if you want it, please reach out to them and they can send it to you. It's possible that after you get off, you might get an email of the recording. It's possible. I'm not really sure. But if you don't, please reach out to your manager or admin and we'll try and shoot it off to you guys. All right, 10:04 it is. All right, so for those of you who have been listening to me babble and aren't sure who the heck I am, my name is Blair Newton. I am the president of PBM as well as the co-owner. We put this together today for all of our board members. Again, I mentioned earlier, we had about 200 sign up. We're at about 134. Hopefully that number will go up as we go. We've had a heck of a change in legislation this year. Usually we have a change here or a change there. You know, the milestone and SIRS, all of us thought that was a really big to do. This year is more of an operational change, I guess you could say, as opposed to an infrastructure change. And it's going to affect how we all do things, including management companies, including you guys, including, well, all of us, quite frankly. And it's not going to help financially. It's just going to be more burdensome for all of us. So I asked Anne Hathorn, who's been working with PBM for, gosh darn it, it's probably, I lose track of time, but I'm guessing 15 years now, give or take, Anne, I think, right? And prior to that, when she was with Becker, it was even more. So she's been a friend of the company for quite some time. I trust her. I trust her opinion. I trust her knowledge in in our industry. So I asked her to come do this for you, and she immediately said, yes, absolutely, I'd love to. So I'm going to restrict the amount of talking I have. At the end of the meeting, I do want some of you to stay on, and we'll kind of start wrapping up. I do want to talk to you about, unfortunately, a federal issue that is also going to affect you guys that we're taking steps to get in front of. It will be another webinar, most likely, that I have to talk to you about, but we'll talk about that at the end. So please stick around if you can. If not, I'll send out written correspondence inviting you guys to another webinar about the CTA and the stuff that's coming with that. But for now, I'm going to turn it over to Anne. I'm going to put up her various slides as she goes. So bear with she and I as we do the presenting. And at the end, we'll try and do a Q&A. Again, we've got 140 to 200 people going to be on, so that may be difficult. So hopefully she addresses everything and we don't have a lot of questions. So Anne, I'm going to turn it over to you. I'm going to put up HB 59 to start and we'll go from there.
Thank you, Blair.
Oh,
Thanks
that's
for
not
having
it.
me. And thanks to all of you for coming on this morning to listen. I'm Anne Hathorn. I'm the principal attorney at Anne Hathorn Legal Services, LLC. I recognize some of your names. I've worked with some of you all and the rest of you. It's nice to speak with you. If anybody can't hear me, just put it in the chat, raise your hand, something like that. And hopefully Blair or I will be able to fix that. As Blair said, we have had really, really significant law changes this year. We've been, spared from them for a few years, absent the SIRS and the milestone inspections. But this year we really got hit, and the only group of community associations that is somewhat safe are cooperative associations. But that is usually the case, that the legislature usually first will change the condo law, then we'll change the homeowners association law, and then a few years later remembers, oh yeah, we have co-ops too, we need to catch them up. But as Blair said, the new law changes are really, really very wide-ranging, far-reaching, impact a lot of things. I understand from speaking with Blair yesterday that most of you on the webinar are board members or owners in condominium associations. But we do have some percentage of owners who are board members, owners in homeowners associations. So we're going to talk about the homeowners associations laws as well. And I'm going to start with those. We have two short laws impacting HOAs and then one lengthier one and there's some overlap with the HOA and condo law. And then I'll spend the bulk of the time on House Bill 1021, which is the main bill with the changes for condos. And like Blair said, we'll try to do a Q&A at the end. So if you have questions, please hold them till then, and we'll try to answer them as best we can. All right, so House Bill 59. This is, again, specific to homeowners associations, does not impact condos, does not impact co-ops. It basically has three main parts. And the first part is that it requires homeowners associations to provide a physical or a digital copy of the association's rules and covenants to every member of the association, including new members. And this requirement goes into effect October 1st. So before October 1st, the association has to provide either physical or digital copy of HOA rules and covenants to every owner. Rules are pretty self-explanatory. You know, your association probably has a set of rules that may be adopted by the board. Covenants are in a homeowners association. Covenants are equivalent to the declaration of covenants, conditions, and restrictions, or whatever variation on the name that your HOA might have. That's the superior document for HOAs. It creates the community. It will, include level of high level restrictions, architectural review, assessment authority, things of that nature. So that's kind of the first piece, is that you have to provide a physical or a digital copy. The second piece is that each time the rules or covenants are amended, the association is required to give every member an updated copy. And by that, I assume, even though it's not really written very well, I don't think it means that if you amend one particular rule in a set of 5-page rules, that you're required to print the entire 5 pages with the one rule change and give the whole new copy to everyone. I think you're just required to provide what you amended, whether it be a rule or a covenant. And that's actually already the law in regard to amendments to covenants. But if you change them, you're required to provide a copy of the change to every member. You can, as a board, adopt rules that talk about how you're going to distribute and what the time frame for distributing changes to rules or covenants is. The third piece of House Bill 59 is that in lieu of providing a physical copy of a rule or a covenant or an amendment to a rule or a covenant, you can provide that on the association's website. If you have a website, and if your website is accessible to the members, and if you send notice to each member of the association's intention to post the rules, post the covenants on the website. And if you want to do it this way, which I assume if you have a website, it's probably the easiest way to handle providing rules and covenants to the owners, you have to provide that notice either by mail or electronically to the owners who have consented to receiving electronic notice of meetings and information from the association. So that's House Bill 59, 3 basic pieces. Have to give each member a copy of the rules and the covenants, have to give each member amended rules and covenants, and you can utilize the association's website to post the rules and the covenants, and you're required to give the owners notice that you're using the website to do this. Hopefully that's relatively straightforward. It's pretty short. It's probably tracks with what most of you are already doing anyway. So if you have any questions about that one, just write them down and I'll come back to that at the end. But hopefully that's relatively straightforward. Blair, thank you. The next law, this is also a short one. You're going to see some parallels to this when I talk about House Bill 1021 for condos, but this is House Bill 293. It is specific just to homeowners associations, and it is a hurricane protection law. What it requires, and for those of you who are in condos or have lived in condos, this may sound familiar. It's been the law since, I believe, 1992. For condos, we're required to adopt hurricane shutter specifications. And this went into effect after Hurricane Andrew. So maybe it's a little newer than 1992. But what that law required was condo boards had to adopt a set of hurricane shutter specifications and could not prevent owners from installing hurricane shutters if they wished, as long as the shutters met the specifications adopted by the board. So, the public policy of that law is very clear that we want to allow owners to protect their, the openings into their units, but we're going to give the condo boards a little bit of discretion in what do we want that hurricane shutter to look like? What colors do we want it to be? Do we want it to be rolled down? How far in advance do the owners have to put them up? How soon after the storm has passed do they have to take them down? Things like that. Hurricane shutter specifications is kind of where we start with this. And that's been the law for a long time. So now we have House Bill 293 for homeowners associations that requires homeowners association boards or an architectural committee to adopt hurricane protection specifications. This is not hurricane shutters, because for HOAs, hurricane protection may be a lot broader. And if you read the new law, it actually is a lot broader. What the definition in the new law is of hurricane protection for HOAs includes, but is not limited to, and I'm not going to read the whole thing, I'm just going to kind of go through the highlights: roof systems, permanent fixed storm shutters, roll down track storm shutters, impact resistant windows and doors, polycarbonate panels. I'm guessing those are, panels that you might put up over windows, reinforced garage doors, erosion control, exterior fixed generators, fuel storage tanks, and other hurricane protection products used to preserve and protect the structures or improvements on a parcel governed by the association. So this is what hurricane protection means in an HOA. And so each HOA board or architectural committee in an HOA is now required to adopt hurricane protection specifications. And the specifications can include any number of things: color, style. Do you want to require an engineer to provide plans? Do you want to make sure they comply with code? Of course. So, and we get sort of the same language that we've had for condos and hurricane shutters for a long time, that once each HOA board has adopted these hurricane protection specifications, it can't deny an owner request to install hurricane protection as long as it meets the specifications adopted by the board. I've had several HOA boards ask me questions about this new law so far. And this law actually has been in effect since May 28th, 2024. So it's been in effect for a couple of months. It doesn't have a when are the associations required to adopt these specifications, but it just says they have to do it. So I've had a lot of clients ask me about this, ask me, well, what does this mean? Does this mean that owners are required to install hurricane protection? And the answer to that is no. This doesn't mean that the owners are required to install hurricane protection. It just means boards are required to adopt specifications for what they want to allow for hurricane protection. And as long as what an owner wants to install meets those specifications, the board can't disapprove it. What I have told my clients is that it's probably a good idea for them. And again, this is just HOAs, but we'll talk about this again for condos later on. What I've told my clients is that it's probably a good idea for them to reach out to an engineer or some kind of other professional about what types of hurricane protection specifications they may want to adopt, because each community is so different. We have HOAs that are detached single family homes that may be more focused on, well, what kind of roofs do we want to allow? Do we want to allow people to install generators, hurricane shutters? Or we may have something that's more like townhomes, where we have connected units in one building. We may have different hurricane protection requirements there. So every community is very different. You want to evaluate what you have. You probably want to talk to an engineer or other contractor professional to get specifications in place that are going to meet the criteria of your particular community. Blair is saying in the chat, and Blair, feel free to jump in, like whenever you want. If you want to,
No. I was Pierre asked a question. Do the specs need to be published in the rules and regs document? I said typically they aren't part of the rules, but they need to be adopted in a similar fashion. Do they have to be part of the actual rules themselves, Anne?
It does not say that in the law.
I didn't think so.
It
Okay.
says specifications, which are not defined in Chapter 720, so are different from rules. But, you know, to be on the safe side, piggybacking on what I was just talking about House Bill 59, once the board or the architectural committee has adopted these hurricane protection specifications, they probably need to be given to each owner. They probably need to be given to each owner when they are changed, and they probably should be put on the website if you are intending to use the website for where you're putting your rules. Specifications are sort of equivalent to rules, as are procedures, policies, but they don't have their own definition in 720. So that's a good question. Where would they be published? Pierre is asking. Well, I suppose that they would be published on the website. They would be kept with the association's official records. They would most likely not be recorded in the public records, and they are not required to be. Please clarify the difference between HOA and condo HOA, Penny asks. And I don't want to get sucked into the chat the whole time, but I will answer that question. HOA and condo HOA, the best way to determine, are you a condo or are you an HOA, regardless of what the name of your community is or what it looks like, look at the documents that say declaration of what. If it says declaration of condominium anything, you are a condo. If it does not say condominium in the declaration, then you are not a condo and you are most likely an HOA. Yes, we will attach and send the slides into the chat at some point so that you all can have them. Right, Blair?
Sure.
Okay. All right. So, yes, and we are doing 720 first. We have two small 720 bills. We've talked about House Bill 59. We're talking about House Bill 293. And then we're going to talk about House Bill 1203, which is kind of a bigger bill for HOAs. And then we'll talk about condos. So 293 is hurricane protection for HOAs. Boards have to adopt specifications, talk with your manager, talk with an engineer, talk with contractors about what types of hurricane protection specifications make sense for your particular association. Okay. All right. So let's move on then to House Bill 1203. And this one is a little bit longer. This one's got a lot of stuff in it. This one's got a lot of substantive stuff in it. There is also some overlap here with condos, specifically as it relates to things board members can no longer do, and where the provisions are identical or found in both statutes. I will make a note of that just so you know. So House Bill 1203. Can you please enlarge the documents being presented? Hard to read the very small print on screen. Thank you.
There you go.
Okay, great. All right. Thank you for asking that. Understood. All right. So let's talk about some new requirements for community association managers. This is a little bit interesting because this only relates to community association managers who are managing HOAs, not condos. This bill requires CAMs and CAM firms to annually attend at least one member meeting or board meeting of the association. Now, Blair, I'm pretty sure that when you enter into management contracts with your clients, whether they're HOAs or condos, you probably have something in there about you're going to go to some number of meetings per year. But this law specifically requires you now to attend at least one member meeting or board meeting of the association, and again, only HOAs. Required to provide to the community association members certain information like the contact person, contact information, hours of availability for the management company, and a summary of the duties for which the manager or representative is responsible. And you're also required to post this information on the association's website. Again, I assume that a lot of this information is already included in the management contract, but it is now also the law in the Florida statutes governing community association managers and community association management. Okay, you are required, you meaning community association management company, to provide the members upon request a copy of the contract between the association and the CAM or the CAM firm. This one's a little weird to me because the association's management contract, whether you're a condo or an HOA, the management contract is already an official record of the association. And as such, it's already available to each member upon written request. So it sort of seems like this law is kind of a belt and suspenders, because while it's an official record of the association and it's required to be provided upon written request from the association, it now looks like it's also required to be provided from the management company. So I guess you can get it in one of two ways now. There are now new laws, and again, this is community management, community association management, managers and management companies for HOAs, new statute governing manager conflict of interest, and a mandatory process for disclosure and approval of potential conflicts of interest with managers or management companies. And I'm not going to get too far into this because it's probably something that doesn't come up. It's something that obviously Blair is aware of as a owner of a community association management firm. Community association managers now have some additional continuing education coursework requirements to renew their CAM license, and some of that additional continuing education has to include specifically record keeping, association official records. And as we go through the morning, you are going to see that there is a lot of emphasis both for HOAs and for condos in these new laws on official records. I am not sure why. I'm not aware that there are significant issues with official records for condos or HOAs, but that sort of is a theme. So managers of homeowners associations are required to take additional continuing education classes specifically on record keeping. And that takes us right to the next part of House Bill 1203, which is relating to official records. You are now homeowners associations. This was a requirement for condos for a few years, but now for associations that have 100 or more parcels, you have to have a website or an application, like an app that I guess you could use on your phone or a tablet, as opposed to a website where you have to keep a digital copy of a list of specified association official records. This is not the entire list of official records that's found in Section 720, Section 303, but it is a partial list of official records that associations with 100 and more parcels are now required to keep on the website. HOAs are now required to maintain their official records for at least 7 years. Some of the records you are required to keep them perpetually. Things like the original governing documents, plans, meeting minutes may still be 7 years, but they may now be perpetual. As a homeowners association, you have to provide a copy of records if a law enforcement agency subpoenas them. Again, I assume that if any HOA got a subpoena for official records, you would have been providing them, but now the law specifically says that you're required to do so within 5 days of receiving that subpoena. So please, if you get a subpoena, submit the official records. Okay, so that's official records for HOAs. There's a little bit more that we'll discuss when we get into officers and directors, but that's kind of the upshot. You're required to keep them for 7 years. You're required to have a website if your HOA has 100 or more parcels, and maintain a partial list of the official records and provide records in response to a subpoena. All right, debit cards. Don't use a debit card. Just don't use a debit card. You're not allowed to have a debit card. It's very clear in the law. An association and its officers, directors, employees, and agents may not use a debit card issued in the name of the association or billed directly to the association for the payment of association expenses. If you do use a debit card issued in the name of the association for any expense that is not a lawful obligation of the association, you have committed theft. And the law defines a lawful obligation of the association as an obligation that has been pre-approved by the board and is reflected in meeting minutes or the written budget, either meaning it's an expense that's budgeted or it's a contract that's been approved by the board and documented in the minutes. So I guess what this means is don't use a debit card. Don't ever use a debit card issued in the name of the association. If you do, and you use it for not a lawful expense, you have committed theft. If you use it for a lawful expense, I don't know what happens, but don't use a debit card. That does not include credit cards. And I'm glad, Phil, that you posted that in the chat, because that's where I was going next. Condo associations have been prohibited for using debit cards for a couple of years now. The law that we'll talk about for condos expands that prohibition on debit cards to basically mirror what I'm talking about now for HOAs. But we've kind of been wondering, what's the big deal about debit cards? Why can't you use debit cards? And I think that the reasoning and the difference between don't use a debit card, but it's okay to use a credit card, is because you can get cash with a debit card. You know, you can use a debit card at an ATM and you can withdraw cash. You can withdraw, you know, whatever, several hundreds of dollars. Whereas with a credit card, either you can't or it's not so easy. So the legislature wants to eliminate the possibility of people using an association debit card to withdraw cash and use the cash for their own purposes, I guess. But condo, HOA, don't use debit cards. And if you use a debit card issued in the name of the association and you use it for something that is not a lawful association expense, you have committed theft.
And
Larry,
by the way, PBM
Yeah.
clients, we don't use debit cards. If you have a card in the association's name, typically, I believe it's still probably a Truist card. It is a credit card, so you don't have to worry. You do not have one, not to worry.
Okay, very good, very good. So don't use debit cards. No debit cards. Debit cards are bad. No debit cards. Credit cards are okay. Debit cards are not. All right. Good. No debit cards. Everybody good with that?
Yep.
Okay.
All right.
All right.
Next.
Next, requirement to provide an accounting. This one is weird, and this is again just for HOAs. What it says is, if I'm an owner in an HOA and I want to know how much money I owe the association, like I want basically a copy of my ledger. I want to know how much money do I owe you. I can submit a written request for an accounting, my own accounting. And within 15 business days after receipt of the request, the association has to provide that to me. I can't ask again for another 90 days after that. So basically, this would allow each owner to request an accounting quarterly, 4 times a year. If the association does not provide an accounting within that 15 business day time frame, then it acts as a complete waiver of any outstanding fines that are more than 30 days past due, and which the association has not given prior written notice of the imposition of the fines. So if I request an accounting and I don't get it within the 15 business day time frame, if there were any fines on my account that were more than 30 days past due and that the association didn't give me notice of, those fines are wiped out. This is a really, really, really limited, like, only is going to apply to really small number of circumstances. Bottom line, you have to be prepared, if you're board members and HOAs, for your owners to request an accounting, which basically means you got to tell them how much they owe. Send them a copy of their ledger 15 business days after receipt of request for that accounting. You're also going to have to, if you get that written request and it's somebody who is likely to keep asking for this, keep track of when they requested it so that you know that they can't request another accounting for 90 days. Make sense? One's
Yep.
weird. This one's weird. Yeah. All right.
All right,
Officer
here we go.
directors. Yay. More continuing
Yeah.
education for you guys. Yes. More classes, more classes. This is sort of, there are similar requirements for condo officers and directors. So I'll sort of talk about both globally. Prior to these new laws, if you were a director in a condo or an HOA, when you were newly elected or appointed, I believe it was within 90 days, you had 2 options for saying you were going to be a good director. You could either sign an acknowledgement that you had read, were aware of all of the documents and the laws, and you were going to follow them, or you could take a class. We call them a board certification class, and I taught them, teach them, a lot of other attorneys teach them, management companies teach them, other providers. You know, you go, maybe you get lunch, you get breakfast, you listen to somebody talk to you about the laws for board members. for an hour and a half, and then you get a certificate, and you would have completed your one-time requirement for that board certification. Now you have to, in an HOA, you have to say that you're gonna, you have to complete education specific to newly elected or appointed directors every 4 years, and you have to take the class. It says within still 90-day time frame after being elected or appointed, and basically your class is good for 4 years. You have to take it once every 4 years. If you don't do that, then you are going to be deemed to have been suspended from the board until you fulfill that requirement. That has been the law, but again, prior to this year, you had the option to sign the form or take the class. So if you hadn't done either and you got a notice, hey, it's been 90 days and you're about to get suspended from the board, it was very easy probably for you to just sign that form saying, I've read the stuff and I'm going to comply with it. But now you actually have to take a class. And the association has to keep each director's certificate of completion for 5 years. And theoretically, the DBPR is going to adopt rules to implement and administer the educational curriculum and continuing education requirements. I'm not aware as of right now whether the DBPR is going to allow what it does now. Providers like myself, like management companies, attorneys, other people, to submit courses for these new continuing education requirements and let us teach them, or whether they're going to solely be done through DBPR. I would guess it's the first one. But obviously we'll keep you informed as we learn things. So just be prepared. You're going to have to take more classes. Yet this does theoretically apply for condos as well. The requirements are a little bit different. I'm going to talk about how the requirements for a little when I get to the condo bill. But yes, board members in both HOAs and condos are now required to do some more classes, do some more continuing education. Can the HOA pay for these classes, or does the individual have to foot the bill themselves if there's a fee for the class? That's a really good question. I don't know too many people who charge fees for the classes. Blair, do you? You're muted. Can't hear you.
So no, but I've also heard a little murmur, with some of the groups that I attend, that the DBPR and Bill, this kind of applies to you, and it applies to everybody, but I think what I'm hearing in addition to having live classes, the DBPR is trying to put together an on-demand kind of webinar deal online.
Good.
That kind of like what we're doing today, guys. Like you would go on, it would be sitting there. If you've ever got a ticket and you want to get rid of your ticket, you have to sit through that class online, and then you have to spend X amount of time on that particular class, and then at the end you get a certificate and a verification that you attended.
Mm-hmm.
I hear that that's probably going to be the easiest kind of way to get this done. Now, whether or not they actually do it, unfortunately, what Anne mentioned is true. They did all of this to us with really no path to success and not to do it. They just said, you're going to do this and we're going to figure it out on the fly. Here you go, managers. Here you go, attorneys. Very typical to the state or any government, I guess. But that's kind of where we're at. Unfortunately, we needed to bring it to your attention before we had the solution. So we've got to tell you about it before they've given us a way to help you do it. So
yes. And you'll also hear me talk about this a few more times this morning about other things that you are required to do or that you may want to do, but that you don't have the ability to do yet. But yes, most of the classes are free. But I would take the position that if you wanted to attend a class that wasn't free, that would be a valid common expense because you are required by law to do this continuing education. And that the association could either reimburse you or the association could pay for you to take the class. That would be my position on it. And I would stick to that unless and until we get something from the legislature or DBPR that says, no, this is you got to pay for it yourself. So revenue source, Nancy asks. Yes, probably. Yes. All right. Let's talk about criminal penalties. This is also going to be a theme of the morning. This is also almost the wording here for homeowners association officers and directors is almost identical to the law for condos that we'll talk about shortly. Basically, there is a whole new list of things that you can't do as a director or an officer. And if you do, you are going to be in trouble, and you are going to be in trouble criminally. So let's just sort of go through the list really quickly. You can't knowingly, willfully, and repeatedly violate official records laws, which means that you can't prevent someone from obtaining official records. You can't deface or destroy accounting records intentionally or knowingly. If you do it purposely, if you do it accidentally, that's not a crime. You cannot refuse to release or otherwise provide association records willfully and knowingly, and specifically with the intent to get out of trouble. Like, let's say that there's something in the official records that is going to get the board in trouble or something like that. If you knowingly and willfully refuse to provide them, that is a third-degree felony. It is also a third-degree felony if you knowingly solicit, offer to accept, or accept a kickback. You've never been able to accept kickbacks. Now it is a felony if you do, so don't do that. No kickbacks. And we also have expanded language for things voting and election related that are crimes for directors and officers to do. If you knowingly aid, abet, or advise a person to commit a fraudulent voting activity, if you do that, and if you conspire with someone else to commit a fraudulent voting activity, if you know about a fraudulent voting activity and actively conceal it, then you have committed a crime. And if you are a director or officer charged with any of these criminal violations, you will be deemed to have been removed from office and a vacancy declared. This is specific language in the HOA law, but again, it is almost identical. There's like one tiny little word change in the law for condos. So when we get to that part of condos, I'm just going to basically say, remember what we talked about for HOAs. There's a whole lot of crimes, things that if you do this, it will be a crime, so don't do them. I know that you all won't. This is not, I feel like, again, this is like a solution in search of a problem, but all of these things are now crimes: fraudulent voting activity, destruction of official records, refusing to provide official records, et cetera, et cetera. It's all bad. Don't do it. All right. Moving on. This is kind of interesting. This is architectural control covenants, parcel owner improvements, and rights and privileges. So this is about architectural control in HOAs. And it's kind of self-explanatory. It's kind of like one of those things that seems very obvious. You can't, if you are an architectural committee or a board in an HOA, you can't enforce or adopt a rule or a covenant that basically limits or restricts what someone can do fully inside of their home. If what they want to do fully inside of their home isn't visible from the frontage of the parcel, an adjacent common area, or a community golf course. So for example, if I lived in an HOA and there were an architectural guideline that said, if you want to change a light fixture in your kitchen that no one can see, you need to get architectural approval. That wouldn't be enforceable under this new law. And that seems really reasonable and logical, right? Another provision that now you can't have a rule and you can't enforce a rule or a covenant that requires review and approval for a central AC, a refrigeration, heating, or a ventilating system. Again, if the system is not visible from the parcel's frontage, adjoining parcel, adjoining common area, or community golf course. So if I want to put in a new AC system and it's not visible from any of those places, you can't make me get approval. You can't ask me to, you can't make me go through a review and approval process if it's not visible. Now, if it's visible from the front of the parcel or from the next door parcel or from an adjoining common area, it is still enforceable to require an owner who wants to install it to go through a review process and get approval. Does that make sense? Yeah, Blair.
So hypothetically,
Yeah.
the majority of the HOAs that we have on this call are in a townhome setting.
Mhm.
So, condo folks, this is really nothing new to us, but it's different because, and I'm going to pitch a question that pertains to HOAs. Condo people don't really pay attention because this already applies to us. But with this law, so if I'm going in and I've got a townhouse that's operating under 720
Mhm.
and I want to redo my kitchen, right?
Mhm.
Typically, I wouldn't do an ACC for that. We don't have laws for that. But if there's a common stack and I'm touching said common stack, I would think they would still need approval, no?
Probably, yeah. And I
Okay.
think that would totally be document dependent, Blair.
Okay.
And I don't think that this law would impact that at all, because this law is really only saying visible. It
Okay.
is only saying you can only regulate it, restrict it, control it if it's visible from the front, adjoining parcel, adjoining common area, or community golf course. So common stack, if the documents required approval for that, you could still absolutely require approval for that.
Okay.
Yeah.
Okay.
Yeah. All right. So let's just finish this one up real quick. If somebody wants to construct something, build something, and it's denied by the Architectural Control Committee or the board, if the board acts as the Architectural Control Committee, there has to be a reason for the denial. You have to say, we're not going to approve your request for XYZ because it violates Article 13, Section 2 of the Declaration. And here's what you want to do that violates Article 13, Section 2 of the Declaration. In other words, Architectural Control Committees, boards, if you are disapproving someone's request, you have to be extremely specific about why and what rule or covenant it violates. That's good practice anyway, but now it's the law. Okay? All right. So this is also a weird one. This is an expansion of a law that's now been in effect for a year, and it has been kind of I've gotten a lot of questions about it, and I feel like it still has some it could be fixed, or it needs to be interpreted, because I think I understand the intention, but it's an open question as to how far it goes. So basically, last year, HOAs became subject to a law. If somebody puts something on their parcel that is not visible from the frontage, an adjoining parcel, then the board can't regulate or restrict it. And there was a list of things that installation of items, if it's not visible. This list of items was really weird. Artificial turf, boats, flags, and RVs. But the list was not exclusive. So I think, again, the intention was, if we can't see it, if no one can see it, we are not going to care about what you're putting in your backyard, whether it's a boat, whether it's artificial turf, whether it's an RV. If it's not visible, we don't care. So now the non-exclusive list of things that we don't care about if it's not visible has been expanded: vegetable gardens, clotheslines, and the areas where it has to be visible from for us to care have been expanded. So again, you can put anything in the backyard, in the parcel, as long as it's not visible from the front, adjoining parcel, adjoining common area, or community golf course. And again, I think the intention is, if no one can see it, we're not going to regulate it, because we don't want the board, the architectural committee, to be climbing up on somebody's fence to look in the backyard to see if there's something there that shouldn't be there that nobody can see. Does that make sense? Blair, you good on that one?
Yep. Let's hit the fines and the parking. I think we're good on this one, right? Yeah.
Yeah. We're almost done with HOAs, and then we'll get into condos. Fines and suspensions for HOAs. Again, it basically is saying reasonable things in this law that says, if the violation has been cured by the time we get to the fining hearing, or the suspension hearing, then you cannot levy a fine. You cannot levy a suspension. I think this makes sense. I think it's reasonable. And also, homeowners associations can no longer fine or suspend use rights if you leave trash cans at the curb or end of the driveway less than 24 hours before or after the designated day and time of pickup. HOAs also cannot levy fines or suspensions if you leave holiday decorations or lights up longer than the governing documents allow, unless you leave them up longer than 1 week after the HOA sends you written notice that they have to come down. So those are kind of little nitpicky, very specific things that HOAs can no longer fine or suspend use rights for. Good.
Yeah, I think we've got a Mike Phillips. I think you're asking a question. If you don't mind throwing it in the chat, we're going to do probably a Q&A at the end. There was a question. We kind of went backwards. Bill asked about if there's a hypothetical screen porch item that described as visible. It doesn't matter if it's enclosed or visible. Bill, you're not operating under 720, so this one doesn't really resonate. So we're still in 720. I know it's so confusing because some of you are set up kind of the similar way. So this stuff doesn't really apply. Now, one thing, and I did want you to touch on real quick with this fine thing for our HOAs that send out fine letters. The structure of the letter is kind of, or has been in the past, hey, Anne, you've been fined because you have a pink house, and if it's not rectified in whatever the timeline, said fine is $100 per day for a maximum of $1,000. If you don't show up for the meeting, consider it levied. That is no longer the path to this letter, correct?
Yeah, it's a lot more cumbersome, and the legislature just keeps deciding to mess around with the fining statute every single year. You are allowed to levy fines, but you have to give written notice of the right to a hearing. You have to hold the hearing within 90 days. If the violation has been cured before the hearing or in the manner that the letter told you to, then you can't impose the fine. You can't impose the suspension. So I mean, it's basically the same thing, but you just have to be very specific about what has to be done to cure the violation, how much time you have, that a fine or suspension may be levied, and if it gets cured before the time frame or before the hearing, then you can't levy the fine and you can't levy the suspension.
Okay. For you HOAs, your manager will talk to you a little bit about that, but this is different, and we want to make sure we do this properly. So that's all.
Yeah, and again, they keep changing the fining statutes for HOAs, and we never catch up. We never catch up. All right, parking. All right, this is a big one. This is section 720.3075, and it says some big things. It says that homeowners associations may not prohibit homeowner or others from parking a few different things. Personal vehicle, including a pickup truck, in the property owner's driveway or in any other area where they have a right to park. So this mainly impacts associations that may have rules or covenants that say no pickup trucks. Are you now allowed to park pickup trucks in the driveway? I think you probably are. And I'm gonna go down a little bit of a rabbit hole once I'm finished talking about this a little bit, because there are a couple of ways that this may not apply to you, a couple of ways that it may. You are no longer allowed to, homeowners associations prohibit people from parking work vehicles in the property owner's driveway. First responder vehicle on public roads or rights of way, I think that's always been the law, but now it seems to be in a different spot. You also, HOAs cannot prohibit owners from allowing contractors or workers on owner's property because the contractor or worker is not on a preferred vendor list, or because the contractor doesn't have a professional or occupational license. What in the heck? So, if your documents require contractors to be licensed to do certain work, you can't prohibit owners from having unlicensed contractors on their property. I don't like that. I don't know how that one shakes out if it gets challenged. You also cannot prohibit owners from operating a vehicle that is not a commercial motor vehicle as defined in another section of the statutes, in conformance with state traffic laws on public roads or rights of way of the property owner's parcel. This is a big one because most associations I represent have some kind of prohibition on commercial vehicles being parked on the property. And the first thing you have to understand is that the definition of a commercial motor vehicle in section 320.01 subsection 25 of the Florida statutes is like this narrow. It only relates to how heavy is the vehicle, how much does it weigh, how big is it, does it use special fuel. So the statutory definition of commercial motor vehicle is very, very, very narrow, and your association definition of commercial motor vehicle is probably a lot broader. So the question that a lot of my clients have been asking me is, can we still prohibit commercial vehicles? Our definition, which probably is, you know, does it have commercial lettering, signage on it? Is it used for work? Can we still prohibit commercial vehicles from being parked on property? And the big dividing line there is probably, do you have public roads or do you have private roads? If you have private roads in your homeowners association, you are still good to prohibit commercial vehicles, whatever your definition is, as long as they're not public roads or public rights of way. And the other rabbit hole that I said I was going to go down a little bit, even if you have public roads, does this law apply to you? It may not if you don't have language in your homeowners association documents that automatically incorporate law changes that were changed after your declaration of covenants was recorded. And this is something that you want to ask your own community association attorney about. You want to ask your association attorney in regard to the parking, in regard to the commercial motor vehicles. Is this enforceable to your association if you have public roads? You want to know, do your community association documents have what we call Kaufman language? And again, this is real rabbit hole. This is very legal. This is very technical. This is very specific. Ask your own association attorney about this. If you're an HOA with public roads and you want to know, can we still prohibit commercial motor vehicles? But this is a big thing. So you know, this is something that's going to impact a lot of associations. All right, last couple things actually for HOAs. Assessments and installments on assessments. You can't do compound interest on assessments that are delinquent. This has been a thing for condos for a long time. So now for HOAs, no compound interest. And electronic voting, this also is kind of we always thought this, but now it actually is in the law. You are allowed as an owner in an HOA to consent to electronic voting. If your association is doing electronic voting, you're allowed to consent to electronic voting electronically. You do not have to sign a physical piece of paper and provide it to the association. You can send an electronic consent to electronic voting. Okay, Phil has asked, what about oversized trucks that do not fit in an allotted space? They impede sidewalk passage. That's something, Phil, you're going to want to ask your own association attorney about and see what your documents say to determine whether that is still enforceable or not for your association. Okay. All right, Blair, anything you wanna follow up on before we?
No, I tried to address everyone's in the chat. You know, there's a couple of you that asked questions. I gave a similar response today, and unfortunately, some of the stuff is document specific, and this is broad scope statutory stuff, and as much as I want to save you the 250, 300 an hour with Anne's input, but it's just too risky. She just,
especially with the commercial vehicles on the public roads. Talk to your own attorney. Please.
All right, and what are we going to, HB 1021 or HB 1203?
We just did 1203. We are now on 1021. This is
1021
condo bill. This is a very long bill.
Are you seeing it now, Anne? Is it HB 1021?
That is
okay,
it. Thank you very
cool.
much.
Rick, I see Rick's got his hand up. Rick, can you pop it in the chat, please, if you don't mind?
Blair, I'm having troubles with the chat, so.
Okay, shoot, go ahead.
Well, my question was, when we were talking earlier about not being able to refuse architectural change inside a home, does that inside a home include the garage?
Well, that's a very good question. I don't know off the top of my head. Are the garages in your community considered part of the unit? Do you know?
I would think they are, but we have restrictions of what you can do in a garage, which one of them was parking, which goes to the wayside.
Yeah.
But we have restrictions on like storage and building inside a garage.
So yeah, and so here's how the law reads. This is a really good question. Basically, the association cannot do anything that limits or places requirements on the interior of a structure that is not visible from the parcel's frontage or an adjacent parcel, an adjacent common area, or a community golf course. The way I read that is that you are probably still okay to enforce those restrictions on what you can and can't do in a garage, because when the garage door is open, it is going to be visible from the parcel's frontage, possibly an adjacent parcel and or an adjacent common area. Make sense?
Yes, that does. Thank you.
Yeah, that's my best answer for you on that. It's a really good question. All right.
Back.
Let's talk about this is condos. This is all condos. And where we have already talked about what is similar or identical to homeowners associations, I will just tell you so that we don't have to talk about the same exact thing twice in a row. All right. Okay. This starts off with some new requirements for community association managers and management firms. Requires managers and CAM firms to return all association records in their possession within 20 business days of termination of a contract. That's already been the law. And now the CAM firm or manager is subject to license suspension and civil penalties for non-compliance. So, you know, if a management contract is terminated, the management company generally has 20 days to return all of the records, or 20 days from a written request or post termination. So just keep that in mind. I know that sometimes that may not be feasible if the terminated management company has to, you know, pay ending bills that come in. You know, they may have to retain some of the association's records, some of the association's funds in order to do so. But obviously the 20 days post termination or post written request is what the law says. So that should be the goal. All right. We have some similar language for conflict of interest for community association managers and management firms as we did for HOAs. But we have a little bit different language here that is condo specific that says if the association gets a bid for a good or service that costs more than $2,500 from a CAM or a CAM firm, it has to be disclosed and the association has to submit multiple bids. So like if your management company has affiliations with other service providers, like there's one that I'm thinking of that's a management firm, but they have like a maintenance arm. So if you had a leak or something and you got a bid from the affiliated maintenance arm of the management firm to do mold remediation, you'd have to get competitive bids for that, because the intention of the law is that you're not locked into using the affiliated entities of the management company, that relationship is disclosed and that you must get other bids to make it more competitive. Makes sense? All right. And all of the conflicts of interest for the management firm, and this is true also with contracts entered into with directors and officers, they have to be disclosed. Those contracts have to be posted, attached to the meeting agenda. And in regard to this specific management company conflict of interest, the board can only approve that type of a contract by a 2/3 vote, as opposed to your typical majority of the board members can approve something and it will be a valid board action. If we're talking about a contract with the management company or affiliated entity, that has to be approved by 2/3 of the board members present, not just a majority. Yes, Blair.
But to be clear, just for our wonderful board members online, that doesn't pertain to just our renewal.
No.
This is only if there's a conflict. So you can approve our contract, no problem.
That's right. You only need a majority of the board to do that. Then that's why I was trying to give a specific example of management company has like an affiliated entity that provides maintenance services. If you're trying to enter into that kind of a contract, that's where you need the 2/3. And yes, competitive means more than one. Competitive is 2. Yes, correct. All right, so that's conflict of interest. It's just, you have to get multiple bids. It has to be disclosed. 2/3 of the board have to approve it. Milestone inspections. You still don't have to do milestone inspections if you are a 2-story or a 1-story condominium association. But now we have also exempted 4-family dwellings that are 3 or fewer stories above ground. So if for some reason you're a 3-story, 4-unit condo, you don't have to do a milestone inspection. Okay. That may apply to a few condos throughout the state, probably not many. All right, I told you earlier, official records was going to be the theme, and my apologies, there is an incorrect statutory reference on that. It should be 718.111 subsection 12, not 301. I went through this yesterday and thought I caught the typos, but I missed that one. Okay. We have some pretty generic things here saying that if records are lost or destroyed, the association is required to use good faith efforts to find or recreate them or recover them as you can. I mean, this may not always be possible, but you have to use good faith in trying to find lost records or trying to recover, restore, recreate destroyed records. The association, this is actually important, and everybody should know this. And this has been the law, although maybe it hasn't been stated in black and white, and now it is. It's that second bullet point at the bottom of page 1. Allows email addresses and fax numbers to be accessible to unit owners if consent to receive notice by electronic transmission has been provided. What does this mean in English? It means that it's been the law for several years. If you want to receive notices of meetings electronically, as opposed to having the association mail every notice to you, if you want them to email you notice, that's great. You're allowed to do that. That's been the law for several years. You have to have written consent on file with the association saying, please email me meeting notices. But the downside to that is that if you are receiving electronic notices of meetings, whether it's by email or fax, if people still use fax, then your email address or your fax number has to be provided to an owner upon written request because it is not exempt. So in other words, if you're getting meeting notices by email, your email address is going to be provided to an owner if the owner requests it.
Can I chime in? It's if they're getting official notice by email by consent, that needs to be shared. But for you guys on this, if we're not doing electronic voting and you've not opted in to receive things electronically, but you're still getting stuff out of the portal, you're all good. But if if we start doing electronic voting and you consent to receive official requests or official notices via email, then you're in this pool. Yeah.
Sort of. Let me just
clarify that. Yeah.
One more distinction. Electronic voting, yes. Electronic notice is another possibility. Like for example, you can request to just get meeting notices electronically without also saying we're doing electronic vote. Okay. 2 things can be done electronically: voting and notice. And Blair is correct that like if the association just emails stuff to everybody because we're doing that and it's convenient, that doesn't mean your email address is going to be provided to everybody. Only if you have specifically said, I want you to send me notices of meetings electronically, and or I want to vote electronically. Okay. Okay. All right. Now, a lot more associations are going to have websites. Used to be that you only had to have a website if you had 150 or more units. Now, effective January 1st, 2026, if you have 25 units or more, you now have to have a website. And just like for homeowners associations about 45 minutes ago, you're required to maintain a partial list, not complete list, but a partial list of the association's official records on your website that is available to all of the owners. Okay? So now you have to have a website as of January 1st, 2026, if you have 25 or more units. All right. You have to, condo associations have to provide official records to owners at no charge if the DBPR subpoenas the association for records that you have failed to timely provide an owner. You have to give them to the owner at no charge. If an owner agrees to get electronically social newsletter, they have not agreed to sharing their private email with all owners. True. Yes, that is true. It is only if you have a written consent on file with the association to receive electronic notice of meetings and or electronic voting. Those are the only two circumstances where you have, in essence, agreed to share your private email with all owners. It's a big deal. It's a big deal. I have had owners that have withdrawn their consent for electronic notice of meetings because they don't want their private email out there. So tread carefully. All right, more official records. You are required, if you are a condo association, to now maintain additional financial records. Kind of expanding the list of accounting records in the official record statute. You're required to have invoices and other documentation that substantiates any receipt or expenditure. Important though, invoices and that other documentation are not included in the partial list of official records that you are required to have on the website. So you're going to have to do a lot of cross-referencing if you're in the category of associations that are now going to have a website, because you don't have to keep all the official records on the website, although you can. But it's not an exact list of what has to be on the website versus what are the official records that we have to maintain. I hate this one, and you guys are probably going to hate it too. You are now required as a condo association to respond to a records request with a checklist of all of the records provided. As well, yes. I can do other things with my fingers too, but like, yes, those are good too. You are required to provide an owner with a checklist of all of the records provided. And you are also required in that checklist to include a list of the records that you did not provide. I'm not exactly sure, 22 days into this law being effective, how best to handle that. I have advised the few clients who have asked me so far, why don't you do this? Why don't you just copy and paste the entire list of the official records from 718.111 subsection 12, have a little check mark, a little space before each one. And if you get an official records request from an owner that wants, let's say, I want the owner roster, I want the board meeting minutes from, January 7th, 2024. So you get that records request. So what you're going to do with your checklist is you're going to check off roster and you're going to check board meeting minutes. And then you're going to have a notation at the bottom, all unchecked items not provided because they were not requested. I don't know a better way to handle that at this point. This is dumb. But that's kind of how I would advise associations to do it at this point. It's just to copy and paste the entire list of the official records, physically check, I will repeat the number of that statute, physically check the records you've provided, notation at the bottom, unchecked records not provided because they were not requested. The number of the statute, the official record statute for condominiums, is section 718.111 subsection 12, and I am putting it into the chat. Blair, you have anything there?
No, please don't make an official records request, anybody. please just don't do it. It's just brutal. So
if
yeah.
Official records, Nancy, if official records are on the website, can requests be referred to the website? Yes. And that may be the easiest way to avoid all of this, because the law does allow associations the option to make the records available electronically. Now, that may require a lot of work on the front end for the boards and or the management companies to make sure that like every single piece of paper, everything that is an official record is being put onto the website contemporaneously. And also to make sure that you have enough, bandwidth is not the right term, but it's kind of the right gist on the website to be constantly adding the official records to the website, because keep in mind that a couple of years ago, a lot of these records are now required to be kept perpetually, and most of the rest of them are required to be kept for 7 years. So you're not in a position for most of them to be dropping them off of the website because they're no longer required to be retained.
So Nance, let's not do that. So managers, PBM managers on the call, we're not doing that yet. We're just not there. So plus I don't know how we give a checklist of what we provided. If we just say, go to the website, it'd be hard to provide
You
the
don't, I don't think
checklist.
you have to provide the checklist if you say go to the website, Blair. I think that might be
Well, that would be
one of
nice.
the benefits to saying go to the website. If the requested records are posted on an association's website, the association may fulfill its obligations under this paragraph by directing to the website or the application all persons authorized to request records. But then it does, the following paragraph is the stupid checklist. Ugh. Yeah, I'm not sure, honestly. How far back do you need to have posted on the website? 5 to 7 years. It's 7 years for almost everything. There are a few exceptions to that. One of them is bids. Bids you only have to keep for 1 year, and documents related to membership meetings, votes, elections. All of the records for those things, like notices, proxies, ballots, even the silly little white inner blank envelopes, those things are all required to be kept for 1 year from the date of the meeting or the election. But everything else is either 7 years or perpetual. Yay. Okay. Also now the DVPR is allowed to request access to an association's website to investigate complaints relating to unit owner access to official records on the website. That would be fun too. All right, so official records are, as Blair said, not good. And we are moving on to criminal violations. We talked about criminal violations with House Bill 1203 for homeowners associations. This is the specific list of criminal violations for condos. It is almost entirely identical, so we're not going to rehash. Basically, it's destroying the records, not providing records, fraudulent voting activity. Don't do any of those things except in kickbacks. If you do any of those things, you have been charged with a criminal violation, you are deemed to be removed from office and a vacancy on the board declared. Okay? All right. Blair, how are we doing on time? Am I okay? We've got not too much more to talk about, but
Yeah, I think I put it to 11:30. So if we can maybe get through content by 11:30, and then maybe we do a Q&A, or I deal with it. We do that. It seems like we've been doing a lot of questions as we go, to be honest. So I think we're okay. Probably not with the Q&A.
I will try to streamline a little bit of it and repeat where necessary. All right, budgets, financial reporting, and reserves. Upshot here, you are required as a condominium association to prepare a year-end financial report. At the conclusion of each year, the level, whether you're required to do audit, review, compilation, or receipts and expenditures, depends on your total annual revenues. You have historically been able to waive or reduce the level with an owner vote. There was a time a few years back where you could only waive for 3 years in a row, and then you had to prepare your correct level based upon your total annual revenue on the 4th year. That got repealed. Now we are more restricted. You cannot waive or reduce your statutory level for more than 1 year in a row. If you have to do a structural integrity reserve study, that means that you are 3 stories or more in height. You are required to provide the owners with a notice that the structural integrity reserve study is available for inspection and copying within 45 days of completion You are also required to provide notice to DBPR upon completion of your structural integrity reserve study. There is currently no form on the DBPR website for notifying DBPR that you have completed the structural integrity reserve study. This is another one of those, hey, you have to do something, but we're not going to help you do it yet. So stay tuned. Okay. All right. Meetings of condominium associations. This is another 2 thumbs down for me. Don't know what Blair thinks about it, but I think this is very, very silly. Blair says 2 thumbs down as well. The bill requires associations with 10 or more units to meet quarterly. I assume that means board meeting. And 4 times each year, the agenda must allow members to ask questions to the board about the status of construction or repair projects, revenues and expenditures, and other condominium issues. This sounds really fun. So basically, if you are a condo with 10 or more units, you have to have 4 meetings a year. And 4 times a year, you have to include an agenda item that is not a proper agenda item. And the agenda item is basically, hey, owners, let's let you just ask questions about stuff that we have to answer. So be prepared for that. The other piece of this meeting, the notice for meetings on assessments has to include the cost and the purpose of assessments. It already says that in the law. But if the assessment is for a contract, like let's say you're levying a special assessment to pay for replacement of a roof and you're entering into a contract for the roof, you have to include a copy of the contract with the notice for the meeting where you're going to levy that assessment. So that could include a lot of paper because, you know, some of these contracts are quite lengthy, but that's what the law says.
And what about posting? That it doesn't say anything about posting. So I assume, because in that other verbiage they talked about, I don't know, what was it, the conflict stuff, you had to post it along with the agenda. It doesn't say anything here about posting said contract. So is it just for the mailer, the 14 days prior, the notice of special assessment meeting, that we send the contract with it?
Well, it actually, here's what it says, Blair. It says if an agenda item relates to the approval of a contract for goods or services, a copy of the contract must be provided with the notice and be made available for inspection and copying upon a written request from an owner or available on the website or through the application. So copy of the contract must be provided with the notice. I would take that to mean that you must post it as well, because you are, in addition to being required to mail or hand deliver notice of an assessment, you are also required to post the notice of the assessment. So I think you also have to include a copy of the contract on the posted notice.
Oh dear. Okay.
Which again is for dumb, but here we are.
It's absurd. So everyone, you get ready. You're going to have a bulletin board this big just to fit a contract. It's insanity. Hopefully they fix this.
Yes, hopefully they fix this. I don't know whether they will, but hopefully they will. All right. Director education. This is fairly similar to what officers and directors in HOAs have to do. You have to, again, as a director, say both that you have read and understand and will abide by the laws and the documents and take continuing education. You are required to take 4 hours of board training, which includes instruction on milestone inspections, structural integrity reserve studies, elections, record keeping, financial literacy and transparency, levying of fines, and meeting requirements. And annually, you have to complete at least 1 hour of continuing education about recent changes to the condominium laws and rules during the past year. You know, I think in theory, this is a good idea. We should all strive to have educated board members, but it seems a little heavy-handed to me. And this goes into effect. This is each newly elected or appointed director. You have a year before being elected or appointed, or within 90 days after being elected or appointed to complete this, okay? Am I aware of any active pending lawsuits challenging any of the 2024 legislative changes? I am not aware of any active or pending lawsuits. I am monitoring this. I am on a online listserv with, several hundred community association attorneys throughout the state. It's a subcommittee of the Florida Bar. We are, corresponding about the new laws, asking each other what we think they mean. Not aware of any litigation. I will update you if that changes. So,
Hey, and up higher up in the chat, Tad and Dory asked actually good question. So Tad says, can an open question, can we specify? I think the answer probably you're going to say is no, because it kind of says it needs to be a general question about spending or whatever.
Yeah.
But you may want to answer that one. And then Dory's question is, I think it's a big no, but both are good questions.
can we give a condensed version of the contract? I think a big no. I think that's
Yeah.
a big no.
That's what I thought too.
And so the other question was about, can the agenda item be more an announcement in the, let me scroll up. Can the open question agenda item be more an announcement in the current meeting, requesting the unit owners to submit their questions to be included in the next meeting? I think probably, as long as you're doing it 4 times a year. And that's, but I also think that you still have to take open questions. You can't just limit the open forum questions to the owners who submitted questions prior to the meeting. I think you also have to allow, hi board, I have a question about stuff.
Boards, I would suggest we have those types of meetings like early AM before everyone gets their liquid courage after happy hour. So if we're stuck doing those types of meetings, I'd suggest you do it early and get it out of the way, because you know what happens when people hit happy hour and then come to meetings. So
Yeah. So owners can submit questions prior to the meeting and the board must answer these questions in an open meeting. Yeah. I mean, that is what it says. And I mean, again, I don't understand where a lot of this is coming from. I think I understand. I think that it is probably like 1 or 2 condos in South Florida that they have a problem with the board not talking to people, and someone has the ear of some state legislator and they're like, this is a problem statewide and boards aren't talking and boards aren't answering questions. So we're going to make everybody do this now. That's where I see this kind of coming from. But yeah, you gotta do it. It's ridiculous. It's ridiculous. The right to ask questions relating to reports on the status of construction or repair projects, the status of revenues and expenditures during the current fiscal year, and other issues affecting the condominium. All right. So yeah.
and real quick,
Yeah.
Jeff asked a good question. So the 4 hours of training, his question is 1 hour training for law changes every year. Is the 4 hours about milestone and SIRS a one-shot deal? Kind of reads that way.
It kind of reads that way. It's kind of reads that way. It is a one-shot deal, after which it is 1 hour every year about new law changes. Again, I am not 100% sure. I am hoping we're going to get some guidance on this. This seems like something that the DBPR could easily provide guidance on. But that is kind of how it reads to me, as if the 4 hour is a one-shot deal coupled with 1 hour every year on law changes. What about an emergency meeting regarding one specific issue regarding a special assessment? Are open questions permitted, or must questions be limited to the specific issue? Open questions are not permitted at every meeting. The association, the board is required to allow open questions at least quarterly, 4 times a year, not every meeting. So emergency meeting regarding one specific issue regarding a special assessment would not be subject. You don't have to open it up at every single meeting. All right. Let's talk briefly about voting. This is another weird one. You may be aware that if you are delinquent in assessments owed to the association, the board can suspend your voting rights. This puts in kind of another layer of due process. It requires a condo association to notify a delinquent owner that his or her voting rights may be suspended due to delinquency at least 90 days before an election. you know, this is something that I think you sort of have to put on your radar. You have to put on your pre-election timeline if you are an association that wants to suspend voting rights for delinquent owners, that you just have one more step in place farther back in time that you need to make sure you check that box and notify those owners at least 90 days in advance if you do want to suspend their voting rights. It's just more work for you as board members, but I think that it's reasonable. All right, again, as we did, Lori, I'm going to answer this in just one sec. Let me just try to finish the voting, and then the rest of this is kind of repeats of what I've already talked about. Allows cooperative and condo unit owners to consent to electronic voting electronically. We talked about this for HOAs. And if the condo board authorizes electronic voting, basically each owner gets to vote electronically unless and until the owner opts out. This is how I have always handled all of my resolutions and written consents for electronic voting, but apparently that is the law. All right, Lori, questions may or not be answered at the meeting if the board does not have the answer. Does the board have to announce when the question will be answered, and does the question have to be answered at a meeting? I don't know. I don't know. I don't know. I think that it may be reasonable that the board may not have answers to all of these open questions at the meeting, which is one reason I think that giving advance notice, hey, our March 31st meeting is going to be our open question meeting. If you have questions, please submit them in advance. Yes, we will take questions from the floor, but we're going to be a lot more able to answer your open questions if you have submitted them to us in advance so we can research and get information. So I think doing that may enable more complete answers at the meeting, but I think it's reasonable to say they're not going to have answers to everything. I think you will have to say, we don't have an answer for this. We're going to get you an answer to this. No, I don't think the board has to announce when the question will be answered, obviously, as soon as you can. Does the question have to be answered at a meeting? I don't know. I would say no, but maybe better safe than sorry, and answer it at the meeting, as well as providing an individual owner with an individual answer. Okay, reading the chat. Caveat is if board serving consecutive years for up to 7 years, if you leave the board and then rejoin the board, yes, of course, you'll need to retake the 4-hour education again. Is this accurate? I believe that is accurate. Yes, yes. It's kind of like the board. It's already says that for the old requirement for the board certification course. If you leave the board and rejoin the board, then you have to take it. Then you have to take it again. And the unit owner is delinquent on one of the units owned, are his voting rights suspended only on the delinquent units or on all units he owns? I do not recall the answer off the top of my head, but I can find that answer for you. All right. I think that the answer was that it was suspension for all, but I want to look that up just to be sure I'm giving you the right answer. All right. So yeah, the open meeting questions is going to be ridiculous in my opinion. All right, just a few more things. Hurricane protections for condominium. We talked about hurricane protections for HOAs, and I kind of gave you the background that this arose from condo law for about the last 30 years, requiring boards to adopt specifications for hurricane shutters. This has now been expanded in the condo law to require boards to adopt specifications for hurricane protection, which is intended to be more all-encompassing than just shutters. It's intended to include code-compliant windows and doors, impact-resistant glass. And so now we have to expand the specifications that our condo boards have. Our condo boards cannot prohibit owners from installing hurricane protection that meets the specifications. If hurricane protection is owner responsibility, like for example, if your declaration of condominium says owners are responsible for maintaining windows and doors, you can't make the owners install hurricane protection. But if they are required to replace their windows or doors, say, they have to do so with code compliant windows and doors. Also, the law says that owners are not responsible for removal and reinstallation of hurricane protection if the removal is necessary to repair the condominium property. I don't know about you, Blair, but I get this question a lot. Like, we're going to be painting and waterproofing the building. who is responsible for paying to take down owner hurricane shutters.
That's why I highlighted it. This is the biggie of, other than the education, I'd say this is a pretty big issue, this one.
This is a pretty big issue. Yes, yes, exactly. Yes. So yeah, so if the association is, if the hurricane shutters have to be removed in order to paint the building, waterproof the building, then the association is going to be responsible for the cost of removing them. The law is not nearly as clear on who has to pay to put them back up. And it's just, it's really all over the map as far as that goes, in my opinion. It basically says that, you know, the association is clearly responsible for paying to remove them when it's necessary to remove them. But if you want to replace them, it is going to depend on what they are and what the, I mean, it's just keep in mind the association has to pay to take them down.
And don't you think, Anne, so for those of us that are, or those of you that are in either flux of a project or getting into a project, we really need to consult, you know, whether it's Anne's your attorney or whoever's the attorney, we need to consult with them on direction on those gosh darn shutters or any of that, because this is a sticky one and it could very well be challenged, and you want to have all the backup, not from the manager, but from your legal counsel as to how you proceed. Just you guys as board members don't want to make this call. We really can't make this call because we're not allowed to practice law. So if we're in the middle of it, and the managers know, because we've had meetings on this, we need to be addressing this with the attorneys prior to the project, or if we're in the middle of one, talk now and try and get it out there.
Absolutely, 100%. Yes, for sure. Please talk with your association attorney about this. All right, let me finish up like last 2-3 minutes, and then I'll answer the chat questions that we haven't gotten to yet. Debit cards, no debit cards. Don't use debit cards. Don't use debit cards. Credit cards are fine. Don't use debit cards. Especially don't use an association debit card for something that is not a lawful obligation of the association. Slap and defamation suits. I have been practicing condo law for a little over 20 years at this point, and I have never had any occasion to be involved in a slap or a defamation, but it does exist. Basically, what you're not allowed to do as an association, as a board, is retaliate against somebody for exercising their civic rights to, you know, say my condo board is bad, or call their county commissioner or city commissioner or U.S. representative and complain about the condo board, things like that. So, excuse me, it is a little bit more expansive definition now about slap suits. Again, you still can't retaliate against owners for exercising their rights to contact their elected representatives. You cannot retaliate against owners by increasing assessments, threatening to bring an action for possession, or other civil action. So don't do that, please, as boards. And you also are prohibited from spending association funds in support of defamation, libel, or tortious interference actions against a unit owner. Now, this is an interesting one to me, because I occasionally will write violation letters on behalf of my association clients to owners who may have tortiously interfered with the association's business relationships, or who may have committed defamation. So I don't know if me simply sending a letter violates the law. I don't think it does, but this is one to sort of be aware of. Finally, directors and officers. If you are a director or an officer and you attend a meeting, you have been there to constitute a quorum. Even if you have to leave the meeting because you have a conflict of interest and you cannot vote on the particular item up for discussion, you are still there for the quorum. Okay, that is all for House Bill 1021. Such fun. You want me to scroll back up through the chat a bit?
We got some rapid fire. I think you addressed most of them. I tried to address. So to be clear, guys, you know, we're not an educator. You know, it was asked if we're going to be providing classes or if we're able to. We are not educators. But we will continue to, and this is a push we're going to try and do, is bring in guest speakers, do things of this nature to try and keep you up to speed as to what's going on. Yep. We are not certified, as Anne said, none of us are yet on the 4 hours or the 1 hour. Like, we don't even know how this is going to go down. So please bear with us. We'll share when we know the nice thing about the new portal and sync is we can direct email just to board of directors. So as things come out, which we'll be talking about another thing as we wrap this up, as things come out, we can communicate directly with you. So if there's a class, or if Ann and I get some inside knowledge of the DBPR is going to be doing their own thing, we'll send you that link. We'll do whatever we can to help facilitate you getting this done, because obviously we need a board to work with, and your association needs a board, to maintain its status. I mean, if you don't, you're in receivership. So we want to make sure you guys have the means, but we just can't provide it. We're just not, that's just not the business we're in.
And my firm is a licensed provider with the DBPR for doing the board certification classes. As Blair said, nobody's got the 4-hour thing right now. I do board certification classes periodically. So, I'll alert Blair if anything changes on the DBPR front. But, we're all kind of flying blind here. We're 22 days into these new laws, and we don't have a ton of information. So we're kind of all in the same boat. Let me hit some of the questions in the chat. Can a condo association still prohibit pickup trucks in assigned parking spots? Yes. The trucks is only a law for HOAs, not for condos. Okay. Do delinquent fees for voting apply to both POA and individual association fees? Can a homeowner vote in an association election if they are delinquent on POA? That's going to depend on whether the POA is considered a condo or a master association, which is governed under Section 720, Chapter 720. So it's probably something that you want to talk to your individual association attorney about, whether your POA is also a condo association or not. All right. What if a resident parks a work vehicle in a condo lot? Again, none of the parking truck stuff applies to condos. It only applies to HOAs.
All right. So we're going to start wrapping up. I think Ann did a wonderful job. Thank you so very, very much. You've really helped us through this. I'm sure everyone found it extremely informative. We will do our best. I've got a bunch of questions. Are we going to get a recording? Are we going to get the handouts? What we'll try and do is put together an email with the link to the recording, and then I'll attach the documentation that Ann provided that I put on the screen for the share. So you guys should have all of that. It's Teams has a function where it uses AI to transcribe all of our, I guess, discussion. I don't know how that's going to look, or if you'll want it, but I think it'll be provided. Again, this is our first webinar on Teams, so bear with us. We're kind of learning along with you. So we'll try and get that to you guys. I'm thinking I'll write it today, most likely, make sure it's okay, and then blast it tomorrow. But if I get to it and it gets out today, then hurrah. Before you get off, because I see everyone saying thank you, and you're more than welcome, and I thank you guys for attending. By the way, at one point we had like 155 people, so that's pretty gosh darn good.
Yeah.
Before you guys leave, please, board members, you're going to get correspondence from us again pertaining to the Corporate Transparency Act. Google it when you get a chance. Unfortunately, it's double thumbs down for Ann and I. For anybody, it's going to be double thumbs down for you guys. But the federal government has lumped you guys as community associations. They're considering you owners of the association, and thereby part of this Corporate Transparency Act is we have to file with the federal government and follow all of these different provisions and restrictions and quite frankly, fines if we do not do it. So we're going to probably have another webinar, and not probably, we're going to have another webinar like this to discuss this. But we as a company have taken some steps to work with the same CPA that files your year-end tax returns. We're talking to them about engaging them to assist you guys in filing this requirement. So it'll kind of go hand in hand with your year-end taxes. So it's going to be let's call it oversharing. Some of you are like, oh, we don't want our emails shared. This is more than that. So we're trying to hire a third party to make sure your information is safe, make sure you know it's done, make sure you guys as board members understand the implications if it's not done, because unfortunately this is not this isn't a management thing. This is unfortunately an organizational thing that you as an organization or you as a board member have to do. We're just trying to provide a path to get you there. So we'll have another one of these. I encourage you please to attend it because it's a lot to explain. I'm not an expert at it yet. We were hoping that the various lobbyists would get you guys or us out of this mess. They've been unsuccessful. So here we are, and we need to get it done by the end of the year. So we will be ramping this up probably August, September to do a push. We'll be signing engagement letters with the accountant if you, as a board, so choose to do it that way. If you don't, you've got to do it by yourselves, and that's just going to be I wouldn't recommend it because none of us really know what it is. So that's the next hot topic. I know we gave you guys a lot of information today, and I'm sorry, but you can see why we wanted to share it. It's pretty important stuff, and it affects all of us. The state is trying to help, although they're going to end up costing you guys more in time and in finances. I mean, the more work that they put on you or us or anybody, it's time and money, and it's unfortunate, but we'll get through it. And with some guidance from Anne and other folks, we'll get you guys there. But we just need you to work with us, and we know we're asking a lot as a board member, as a volunteer, but it's not coming from us. It's coming from the powers that be, and we're just trying to disseminate the information.
And thank you all for serving as board members. It's really, really, really important. Really important. Thank you.
Blair, I have one quick question. I'm not able to get into chat to ask it.
No worries.
With the HOAs, can I install a washer and dryer in my condominium if it's not visible from outside my unit?
Probably. The not visible is only for HOAs.
But I can install a washer and dryer.
Again, 720. What Anne's saying is we're only talking, when we talk about that provision, we're not talking about condos. We're just talking about really your single family homes or your townhomes that operate under 720.
If some units are allowed to have washer and dryers in their unit and I'm in the same building, can they prohibit me from putting a washer and dryer in my unit?
That's going to depend on your own documents. You'll want to talk with your association attorney about that.
Yeah. Sorry, that's a general one.
Yeah, that's a little too specific for to answer in the chat. Blair, thank you so much for having me. I appreciate it. And thank all of you for listening and paying attention and asking great questions.
Yep. Thanks, guys. We'll be chatting soon. Thank you for your continued support. We really do appreciate you guys. And that's a wrap.
Thank
All right.
you.
Adios.
Bye-bye.